The law surrounding citizenship in Ireland is mainly to be found in the Irish Nationality and Citizenship Act 1956. The conditions for the issue of a certificate of naturalisation. In order to become an Irish citizen, you need a certificate of naturalisation to be issued by the Minister. The Minister may, in his absolute discretion, grant an application for citizenship in Ireland if he's satisfied that the applicant is of full age, is of good character, has had a period of 1 year's continuous residence in the state immediately before the date of the application, and during the 8 years immediately preceding that period has had a total residence in the state amounting to 4 years, intends in good faith to continue to reside in the state after naturalisation, and has made a declaration of fidelity to the nation and loyalty to the state, and has undertaken to faithfully observe the laws of the state and respect its democratic values. These are the conditions for the Minister to issue a certificate of naturalisation. This used to be a paper-based exercise until October 2023, but Statutory Instrument 498 of 2023, the Irish Nationality and Citizenship Regulations of 2023, allows for online applications. In fact, online applications are now the recommended method of applying. Section 15A, subsection 1 of the Act sets out the requirements for the naturalisation of spouses of Irish citizens, and 15B, subsection 1, deals with the naturalisation of minors born in the state. In relation to the naturalisation of minors born in the state, the Minister may, in his or her absolute discretion, grant the application if the Minister is satisfied that the minor was born in the state, is of good character, has had a period of 1 year's continuous residence in the state immediately before the date of the application, and during the 8 years immediately preceding that period has had a total residence in the state amounting to 2 years, and has made a declaration in the prescribed manner of fidelity to the nation and loyalty to the state, and has undertaken in the prescribed manner to faithfully observe the laws of the state and to respect its democratic values. When it comes to the calculation of continuous residence for the purposes of the Act, when calculating a period of 1 year's continuous residence in the state for the purposes of the Act, the periods specified in subsection 3, during which an applicant was not present in the state, shall be reckoned as a period of residence in the state, and those periods referred to in subsection 3 are a period not exceeding, or periods the aggregate of which do not exceed 70 days, and an additional period not exceeding 30 days, where the Minister is satisfied that the persons not being present in the state or in the island of Ireland, as the case may be, was necessitated by exceptional circumstances. So if the periods of absence do not exceed 70 days, then the period is considered to be a period of continuous residence in the state, unless or especially if there is exceptional circumstances giving rise to the absence. The good character requirement for naturalisation is an important one, and giving untrue answers to questions on the online application form is an offence and may result in the application being refused or revoked. The applicant for naturalisation must also intend in good faith to reside in the state after naturalisation. Section 6 of the Act then deals with citizenship by birth in the island of Ireland, and Section 6A deals with the entitlement to Irish citizenship of persons born to certain non-nationals. Irish citizenship can also be obtained through foreign birth registration by a person with a grandparent born in any part of Ireland. And Section 19 of the Irish Nationality and Citizenship Act 1956 deals with revocation of certificates of naturalisation. So the Minister may revoke a certificate of naturalisation if he's satisfied that the issue of the cert was procured by fraud, misrepresentation, whether innocent or fraudulent, or concealment of material facts or circumstances, or that the person to whom it was granted has, by any overt act, shown himself to have failed in his duty of fidelity to the nation and loyalty to the state, or that the person to whom it is granted has been ordinarily resident outside the state, or that the person to whom it is granted is also, under the law of a country at war with the state, a citizen of that country, or that the person to whom it is granted has, by any voluntary act, other than marriage or entry into a civil partnership, acquired another citizenship. In relation to the minister's discretion, the minister has a great deal of discretion when it comes to applications for naturalisation and granting the applications. It was thought that the absolute discretion afforded to the minister in the Act meant that he or she was not obliged to give reasons for refusal. That position, however, has been changed by a decision of the Supreme Court in a case Malak versus Minister for Justice, Equality and Law Reform, a 2012 decision. The Minister has a duty to give reasons for refusal. You will find more information about citizenship, immigration law generally, employment rights, right to reside in Ireland, visas, etc., on my website businessandlegal.ie. That's businessandlegal.ie, my website, Terry Gorry and Company Solicitors, and you'll find plenty more information about immigration law in Ireland. I hope you find this video useful. If you do, I would appreciate if you gave it the thumbs up down below, and you may be interested in subscribing to my YouTube channel. And if you're listening to this on iTunes or Spotify, if you're listening to the podcast, the Irish Law and Small Business Podcast, I would appreciate if you left a review or followed me on Spotify or left a review on iTunes or wherever you might listen to your podcasts. Thanks a lot.